Okay, hello, welcome everyone. Thank everyone for joining in. Please get comfortable for Palante's weekly Zoom webinars. Tonight, we have a really important topic that we will be discussing. Tonight is all about MCIs, which stands for Major Capital Improvements, which many of you on this call are familiar with. But this webinar in particular will dive into MCIs and how they work with the new rent laws. Tonight, we have a very special guest who will be presenting Michelle Migunias, the attorney at Collins, Dobkin and Miller LLP law firm. Michelle is a well-versed on MCIs, and we are happy to have her here tonight. And we welcome questions. This will be an open discussion forum tonight. So I will now let Michelle start off and introduce herself.
Thank you, Jakari. As Jakari said, my name is Michelle McGinnis. I'm an attorney with the law firm of Collins, Dobkin and Miller. Collins, Dobkin and Miller is a private law firm that represents tenants in the New York City area, both in court and before administrative agencies like DHCR. The tenants, you probably know, DHCR is the Division of Housing and Community Renewal, and it's the New York State agency that's responsible for rent stabilized and rent controlled apartments. And that includes a landlord's application for an MCI. So initially, MCIs were written into the rent laws as a means to incentivize landlords to upgrade their buildings. As tenants know, MCIs have frequently been used by landlords to increase the rent and can often make up 25% of a tenant's overall rent. The HSTPA, which is the Housing Stability and Tenant Protection Act of 2019, made significant changes to the MCI system. And we'll discuss those in a little bit. And one thing just to know, which tenants here probably know, is that MCIs only apply to rent regulated tenants. They don't apply to private housing or market rate rentals where a landlord can increase the rent to whatever they want. So there's a few helpful DHCR fact sheets. The first one is fact sheet 24, which is just all about major capital improvements. And I want to go over just a couple of the requirements for an MCI. The first requirement is that the work must be depreciable pursuant to the Internal Revenue Code and not other than for ordinary repair. That would be on the page 2 of that, but I'm going to go over these. The second is that it has to be essential for the operation, preservation, and maintenance of the building. And that means you don't get a landlord can't get an MCI for a cosmetic improvement. And the improvement has to benefit directly or indirectly all of the tenants, which means that, for example, if a landlord installed windows, they have to replace all the windows in the whole building, not just half of them. Otherwise, it's not an MCI. And the fourth thing is that the MCI has to meet the requirements of the useful life schedule, which is fact sheet 33. We don't have to put that up now, but fact sheet 33 has a list of common MCIs and when the work, for example, if a landlord installed an intercom that has a 15-year useful life, the landlord would need to wait 15 years before applying for an MCI for a new intercom unless a waiver was filed. Additionally, an owner is required to submit the MCI application within 2 years of the work being complete. And then finally, the cost cannot exceed those set forth in the reasonable cost schedule. The reasonable cost schedule is something new with the HSTPA, and Jakari, that's Operational Bulletin 2021-1. We don't have to put that up now either, but it
Mhm.
probably will be very helpful for the tenants. Prior to the HSTPA, a landlord there was no limit on what they could request for an MCI. The reasonable cost schedule sets forth a list and the maximum amount that a landlord could get. So some of the changes that the HSTP made, for example, prior to the HSTPA, a landlord was entitled to increase the rent by 6% a month for rent stabilized tenants and 15% a month for rent control tenants. Now the rent can only be raised by 2% a month for both types of tenants. And this applies to any MCIs that the owner wanted to collect after June 14th, which is the date the HSTPA, and any that were granted on June 16th, 2012 or later. So right now for all of the tenants, most likely if you had prior MCIs, they should have already been reduced from 6% to 2% at this point, since it's been more than 2 years since the HSTPA. So importantly, the HSTPA prohibits the collection of retroactive rent increases. Prior to HSTPA, a landlord was entitled, once DHCR approved the MCI, they were entitled to retroactively collect the increase from the date they filed the application. So now it's only prospective only, and it's once an MCI is approved, it's on the first day of the first month following 60 days from when DHCR issues the order. And then as I said earlier, the MCI costs have to be considered reasonable, which is where the reasonable cost schedule comes in, where it sets a maximum amount for a new elevator, a new roof, a new facade. And as I said previous, there was, as long as the landlord could verify to DHCR that it spent the money, there was no limit on what they could ask for. And this is very important for tenants, that MCIs are only permitted in buildings that have 35% or more rent regulated apartments. So if you live in a big building, for example, and you don't know how many of the apartments are rent stabilized, a really good resource is the Department of Finance. If you go to the Department of Finance website and look at your landlord's first quarter tax filing, they are required to list the number of rent stabilized apartments. So that's a really good resource. And you tenants here probably know this, but the easiest way to get to Department of Finance is to go to Who Owns What through Just Fix It and just follow the link and put the information in, and then, look up the tax filings. Sure, the easiest way to do it is to go through, there's a website called Just Fix It, Who Owns What. And if you go into the website, I just Google Who Owns What, New York, and it will come up. And then you just put in your address, and it will give you it will give you all the stats about your building, including links to Department of Buildings, which is great for checking if there's violations, which is the next point, which is that there's no MCI if there's hazardous or immediately hazardous violations or building code violations. But through the Just Fix It site, you could get all the stats about your building and links to HPD, Department of Buildings, ACRIS, which lists the ownership of buildings and properties in New York, and the Department of Finance. And once you get to Department of Finance, you have to just, you could put in the block and lot number, and it will pop your building up, and then you just look for the tax filings, and it goes back 10 years, but you should, for depending on when the MCI was filed, you should be able to go back and see at least what the landlord claimed by way of rent stabilized apartments. And then, as I said, they're immediately hazardous violations or building code violations, no MCI. Although if a landlord during the course of a MCI, by the time, let's say maybe they start off with a building code violation or a hazardous violation, if they cure it before DHCR issues an order, then DHCR will usually just say there's no hazardous violations. And finally, and this is important, is that MCIs used to be permanent, but now they have to be taken off after 30 years. It's unclear exactly how that's going to be monitored since, in a lot of cases, and the MCI increases are not separated out in a tenant base rent. So then, what kind of form DHCR is going to require, or what the landlords will require to get these removed in 30 years is unknown. So does anyone have any questions on just that before I'm going to go on to some of the other requirements of the landlord's filing, tenants' objections? So
we do have one question that just came in. Once again, you guys, please, if you have a question, please put it in the Q&A box and we will definitely answer it on tonight's call. So the first question is, hi, we were told that an MCI doesn't raise rent for the residents in Section 8 buildings. Is that correct?
Oh, I'm actually not sure about that. I can look it up quick. I know that for example, if tenants have SCREE or DREE, they are exempt from the MCI. The MCI increases there, but it's baked into the rent, but the tenant doesn't have to pay it because the rent is frozen. I don't know about Section 8. Apologies.
Okay, so we'll follow up with you for the person who asked that question. Thank you. That's the only question we have so far, so you can continue.
Okay, sure.
Yeah.
So as I said, to qualify for an MCI, the work has to be depreciable under the Internal Revenue Code. Common MCIs are like for windows, boiling, heating systems, facade, exterior restoration, elevator, things like that. Our firm frequently battles with DHCR over whether work is depreciable, and it's a primary requirement in the rent stabilization law, and something tenants should definitely raise if they're opposing something, whether the work was actually depreciable under the Internal Revenue Code, because that's the Internal Revenue Code, of course, is federal, so it requires depreciability under federal law, not state or DHCR law. And then the work has to benefit all of the tenants, not just a few apartments. And I already went over that. The application has to be filed within 2 years. This is in a little bit, I'll tell what tenants need to do if they get notice of an MCI, but the 2-year statute of limitations is really important because sometimes landlords will do a bunch of work and they just sit on the MCI, or maybe they need to go back into the work a year and a half after they completed the work. And those are not permitted. If a landlord waits more than 2 years, then they're not entitled to the MCI. We frequently, when we get a copy of the MCI application, we'll go through and we look at, when the work was actually completed. And oftentimes the contractor, when requesting payment, will say when the work was complete. Tenants could also look at DOB permits, but DOB sign-offs can often be a year after work is complete. So that doesn't necessarily, DOB permits or DOB sign-offs don't necessarily say when the work was completed. And then whatever system is being replaced has to have outlived its useful life. And this, Jakari, is the useful life schedule, which lists MCIs, and it has a number next to it, whether it's 10 years, 15 years, 25 years for the item that's being replaced. A landlord can request a waiver if, for example, it's an old system and they don't make it anymore and they can't get the part for it. There's certain in the rent stabilization code, there's a list of waiver issues that might come up for a landlord. But the useful life schedule is important too, because we've certainly seen landlords, replace an intercom system and then, 11 years later, replace it again and apply for an MCI, even though the useful life is 15 years. Often what DHCR will do is they'll subtract the remaining useful life. Say if it's 4 years, they just subtract whatever the cost is from the remaining useful life. So I don't know if that was clear, but that's in any event. So when an owner wants to apply for an MCI, they have to send an application to DHCR. And DHCR, will generally notice the tenants that the landlord applied for an MCI, what the MCI was for, and how much of a rent increase the owner is looking for. If the work qualifies, obviously after after being reviewed by DHCR, if the work qualifies, then the landlord's entitled to raise the rent by 2%. And as we said, it's collectible 60 days from the mailing date of the order. So as soon as a tenant receives notice of a landlord's MCI, what the law says is there's 60 days to respond. But actually, what a tenant should first do if they get notice is submit a FOIL request to DHCR to get a copy of the entire application. Because in order to find objections, you'll want to look through the application and check to see what the work is, what's the useful life being claimed, is it something that benefits all the tenants? Basically, does it meet the basic requirements of the law? And then, so we always recommend first you file for the MCI application. And then once you get the application, you file for an extension of time. We'll often do anywhere from 30 to 60 days, depending on, how big the MCI application is. And then that's usually 60 days to respond. Yes, but that means submitting a FOIL request, and you can request extensions after that. And then once you get a copy of the application, you're going to want to go through page by page and just assess it. You'll want to see whether or not what the landlord said they were told the agency they did was actually done, whether or not, if the landlord replaced the roof, are there tenants complaining that there's still leaks? The defects in the work is a fairly common objection. And what else was I going to say? So yeah, the defects in the work, we often, for example, if, with items like replacement of roof or windows, if there are defects in the quality of the work, sometimes it's easy to say because the tenant's apartment has a leak in it or something after the work is done. Sometimes it could be relevant for the tenants to hire an engineer or an architect to review the work if there's more technical objections or if the application indicates something that doesn't seem right. And so we will often, in opposing MCIs, have an engineer or architect go to the building, look at the work, as well as review parts of the application to make sure that it's actually complying with the law. Generally, if a complaint is submitted regarding defects, DHCR will send an inspector. They don't always, in our experience, but they will often send an inspector. And now with the HSTPA, they're required by law to inspect 25% of all MCI applications filed anyway. So, hopefully if there's a defect, you get DHCR there and you show if the tenants can participate in the inspection, which is something they're entitled to do, but which DHCR and landlords don't often permit, is to just show what the defects are, or certainly be extremely detailed and submit photographs of any of the defects in opposing the MCI. Usually what happens in response to tenants' objections is that the MCI could be denied altogether, or it could be significantly pared down. Maybe the landlord asked for a $15 per room rent increase, and DHCR looked at tenants' objections and looked at the application and discounted certain costs which are not MCI eligible. For example, DOB permits. And frankly, our perspective is anything that is not on the reasonable cost schedule does not get an MCI rent increase. So anyway, so they can deny it altogether, reduce the amount, or approve it in its entirety. So even if the rent administrator issues an order approving an MCI application, even if the tenant's objections were ignored, or the tenants raised issues that the rent administrator just sort of glossed over, the tenants can file an appeal within DHCR, which is called a petition for administrative review, or a PAR, within 35 days. And either the landlord or the tenant obviously can file a PAR. And once a PAR is issued, there's also court review by filing an Article 78, which is that you're asking either the tenants or the landlord ask the court to review DHCR's order. And I don't know how long that is, but that's pretty much it for right now as an overview. But I think if tenants have questions, that would expand the help us dig in a little bit more detail.
Right. Okay. So thank you, Michelle.
Sure.
So we have a question. Can an MCI rider be included in your lease?
Yes, it can be. It can be included in your lease. If you're signing a new lease, absolutely. And they say they want to, the landlord's applied or an MCI is pending, and that way they can raise it mid-lease. Otherwise, if there's not a rider, they'd have to wait until a lease renewal, I suppose. Yeah.
Okay. Well, I have some general questions.
Yes.
Some of them I know maybe the people on the call right now may have, and some people joined in late. So what are the first steps in answering an MCI application?
So the first step is to FOIL the application. That's always the first step. You'll get a notice from DHCR. It'll be a form that says your landlord has applied to us for an MCI, and it will give you the basic outline of what the landlord applied for, but it won't give you the application. So the first thing to do is to FOIL the application. So you submit a Freedom of Information Law request for a copy of the application. And then once you get the application, generally the first thing to do, usually it will say you have 21 days to respond. And usually we will, review the application. And again, depending on how extensive it is, we will then request an extension of time to respond 30 to 60 days.
Okay. And this is something that you recommend someone should go to a lawyer or attorney for, right?
Well, they don't have to. It can get in buildings where they have where there's tenants associations or a collective of tenants.
Hmm.
It's much more. It's clearly more affordable if the tenants can band together,
Right.
hire an attorney. There are things in the law that may not be as clear to tenants, and certainly case law. A lot of DHCR decisions are developed through case law, right?
Mhm.
There's cases that say what might qualify for an MCI and what doesn't, beyond what the law provides, right? Because there's the devil's always in the details.
Mhm.
So oftentimes that comes into case law and DHCR decisions, and tenants may have a hard time accessing that information if they're not attorneys.
Mhm.
Other times, you don't always need an attorney. For example, if a a building, tenants get notice of an MCI, and there's less than 35% or less rent stabilized tenants, that's an easy objection to make, provided you have to know how many
Right.
apartments there are in the building, and going to Department of Finance is good evidence of what the landlord claimed, the
Okay.
number of rent stabilized apartments the landlord claimed. So there's some things like that that tenants can certainly do. But it can be tricky if it's a complicated MCI, um, and tenants file objections
Mhm.
and then an order is issued. We're we've had trouble sometimes because filing an appeal of a negative order, like against the tenant's objections, we're limited to whatever objections were raised before the rent administrator. Whereas attorneys, we might look at it and we might see objections that tenants who don't do this work might not know. So it really depends on the finances
Mhm.
of the tenant group. I think it's certainly if it's just one or two tenants, it might be tricky to retain a private law firm. I don't think anyone does that for free. I could be wrong, but I don't think so. I think it's mostly a private
Mhm.
attorney you would pay for.
Okay.
Mm.
Thank you. So we
Sure.
have a question from one of our attendees. What if the landlord claims an MCI, but it's just for needed repairs?
Right. So, well, that's a really important point, and something we object to a lot. For example, like, I mean, if something is repair work, the law really is clear that it has to be new. It can't be replacement. If a landlord repairs an old boiler, that's not an MCI. That's clearly a repair. If the landlord, paint and scrapes the fire escape, that's a repair. Not if they install an entirely new fire escape, that could be an MCI. If they put in entirely new boilers, that could be an MCI. That's a major objection, and comes to the work, whether the main requirements of the law, which are that the work be an improvement, not a repair, and that it be depreciable under the Internal Revenue Code, um, which, it's not, repair work is not depreciable under the Internal Revenue Code.
Mhm.
You don't get to depreciate repair of a boiler or even repair of an elevator.
Right.
Repair of a roof, no, you don't get to depreciate that. But if you replace your whole roof, yes, that's a capitalized expense.
Okay.
If there's a full exterior restoration, that's a capitalized expense. Something our firm has objected to, and we have a pending lawsuit with DHCR, is local law 11 repairs, which DHCR regularly grants, which in our position is that that's a ordinary repair. It's not a capital expense because it's required every 5 years, and it wouldn't even meet the useful life provisions, which are 15 or 25 years for facade work. So yeah, if work is a repair, it's not eligible for an MCI. And that's up to the tenants or their attorney to articulate an objection to that and say why it's not a capitalized expense.
Mhm. Okay. So I'll move on to the next question. Can an MCI increase be charged to the tenant in the middle of your lease year? And calculate your new rent in the new lease renewal.
Yes, an MCI is collectible 60 days. What's actually like the first month, 60 days, the first day of the first month, 60 days after the order is issued. So yeah, that could be at any time. If it's a new tenant, there'd have to be a rider saying, there might be an MCI in the middle of this lease. Otherwise, all MCIs come at any time they're approved because it's 60 days after approval. And that could be any time.
Mm-hmm. Mm-hmm.
And I wasn't sure of the other part of that question.
Yeah. Yeah, the person who asked that, can you please follow up with the second part? Because it was kind of hard for me to read. The next question is the MCI rent increase applicable if you have an ongoing repair issue in your apartment?
If there are violations that are immediately hazardous or hazardous anywhere in the building, then the MCI should be denied by DHCR. If you have ongoing repair issues, but there's not violations that are immediately hazardous or hazardous with HPD, that's usually the violations that count against MCIs are B and C violations. So you would have to have those and they'd have to be on record. And then, yes, that can be denied for the whole building. If, the landlord need to remedy those before DHCR made a decision, is how how DHCR has interpreted it. Meaning by the time they make the decisions, if the violations are no longer on HPD or Department of Buildings, then they will issue an order. But if you have just repair issues or harassment with the landlord, none of that will stop an MCI.
Mm-hmm.
Again, unless there's a violations or, yeah.
Okay. Are MCIs, are they time limited?
Yes, well, now they're 30 years, right? It used to be that they were permanent, but now any MCI has to be removed after 30 years. I think the tricky part is going to be that not all landlords separate out MCIs from the base rent. They just if a MCI for $12 or something, whatever it might be, is added, that just gets added to the base rent. So earlier, that's, I think, what I don't know is how in 30 years or from 2012, so it'll be less than 30 years, how DHCR and landlords are going to separate out the MCI charges from the base rent if they've not already been separated out. And also there's an issue, and I don't know, this hasn't been raised to my knowledge, but the if the MCIs get collapsed into the base rent, meaning they're not separated out, then when tenants have rent guideline board increases, it shouldn't be the RGB increases, shouldn't the MCI expense should not be affected by the RGB increases, but they are when the MCIs are collapsed into the base rent. Do you understand what I mean?
Mhm.
So if the rent goes up, if your rent is $1,000, but then it goes up to $1,100 with an MCI, for example, then, which it wouldn't be, so let's, because of the 2% cap, but if it's increased and your new rent is, let's just say your rent goes from 1,100 to, I mean, from 1,000 to 1,100, and let's say 100 of those are MCIs, various MCIs. If the base rent is 1,100 on your lease because they've collapsed the MCIs in, then your rent guideline board increases are based on the base rent plus the MCIs, which they shouldn't be. Right? Because your
Mhm.
rent guidelines board increases should only be on your base rent now that MCIs are not permanent. And it'll be something to disentangle in a few years when we, reach the mark of expiring MCIs for landlords who don't separate and have not separated out the MCIs. But yeah, after 30 years, an MCI falls off.
Okay, good to know. Once the MCI is complete, but the work was not as extensive as promised, and it falls apart within 5 years of completion, is there any resources for residents?
Not that I'm aware of because of the time limits for opposing MCIs.
Mm.
It's limited. If certainly if the landlord wanted to come back and let's say they installed a new elevator, they got an MCI rent increase, and then the elevator breaks down in 5 years, the landlord wouldn't be able to get a new MCI on that, or shouldn't be able to get a new MCI on that, and tenants should kick and scream if that
Mhm.
were the case and a landlord did file for an MCI prior expiration of the useful life because the job they did initially was not proper. But really, if something goes after 5 years before its useful life, there's no recourse on the MCI that was granted.
Mhm.
All of the times to appeal have expired. So there's no going back into it that I'm aware
Okay. Um, could you touch on the MCI abatement?
of. I'm not sure what you mean, MCI abatement.
Mhm. That was a question.
Well, I mean, the
Um,
only thing, if a landlord gets something like insurance proceeds or gets money from some other place, that that pays for MCI, they can't get the money from the tenants as well. I don't know if that
maybe that, yeah.
question, I
Yeah,
don't know.
maybe that was it. If you asked that question, let me know if that was helpful. Um, how much can my rent go up based on the MCI rent increase? Is there a cap?
2% of your rent every year. It goes up 2%.
Okay.
So if you have, yeah. And
Uh,
then when the tenant moves out, and certainly for landlords, playing the long game, it's 2% of tenants' rent. And certainly now with the HSTPA, I think some tenants think, okay, it's 2%. It's 2% a year, of course, but it's like maybe we don't want to oppose it because it's not worthwhile money wise for the tenants. 6% is a little bit higher, but at 2%, I know that some tenants think it's not worthwhile to oppose. Of course, when the tenants move out, the landlord gets to escalate the MCI all costs into the new rent. So for landlords, as soon as the tenant vacates, the rent can go from, whatever the full cost of the MCI was, unlimited by the 2% increase, of course, for the next tenant coming in.
okay. This is more of a general question that I have. Should I file a PAR if I disagree with DHCR's decision?
If there's a basis,
Hmm.
yeah, if there's a basis, if you think the decision was wrong, then yes. If you just don't like it, maybe not.
Right.
Like, it's important for tenants to know that DHCR doesn't care if the tenants can't afford an MCI.
Mm,
So if if tenant gets an MCI, DHCR doesn't care if the tenant objects and says, look, I can't pay this, I'm on a fixed income. DHCR doesn't care because it's not one of the reasons to object to an MCI.
mm,
So it has to be one of the you'd need a reason to object. And the part you can't file to file a PAR, the PAR is only based on what was before the rent administrator, right? So an owner submits their application to a rent administrator. The rent administrator reviews it, reviews tenant's objections, issues an order.
mhm.
On the PAR examiner is limited to whatever was submitted before the rent administrator. So if a tenant doesn't like the order, I don't quite know what that means, right? Because if the tenant, say, submitted objections
Right.
and the rent administrator ignored those objections or said, okay, well, that objection isn't valid because of X, Y, or Z, and you disagree with that aspect of it, then yes. Filing a PAR, I guess maybe the question is if the tenants don't object, can they
Right.
file a PAR just because they don't like the order? I think it would be very limited because you didn't raise the issues before the rent administrator, so you can't raise them before the PAR examiner,
Mm-hmm.
right? Any objections have to be raised before the rent administrator.
Right.
And then when that order is issued, you look at it and you say it does or does not address the concerns that I already raised to the rent administrator, or the rent administrator, and this is frequent in my experience, the rent administrator completely ignored my objections, right? Which happens also. And then you just reiterate those objections to the PAR examiner. And they generally will give a more detailed response to whatever objections the tenants had or whatever the decision was, or they overrule the rent administrator and say, yeah, this objection submitted by the tenants was not addressed and it's valid, so I'm gonna, no more MCI.
Right. Okay. Thank you for that, answering that. Next, a question from our attendee that just came in is, our building, gas was turned off by Con Edison. If our landlord applied for the MCI, can they charge us?
Yes,
Mm,
just because a city agency requires work to be done does not mean a landlord is not entitled to an MCI. I guess I would need to see exactly what the application said. Like if they had to replace a system because of the gas, then, then yeah, as long as it would independently qualify, whether the work was prompted by a problem with the equipment or just because it's getting old and we want to replace it before it does break down, doesn't matter,
mhm.
right? Yeah.
Okay.
So even if if Department of Building says, okay, owner, you have to do this, then it doesn't mean that the
Mhm,
tenants don't have to pay for it, unfortunately.
mhm. Okay. Another question, there's an elevator in the building, well, in my building, but I'm on the first floor. Would I have to pay MCI when elevator is replaced? So I'm guessing the elevator is broken. I'm guessing.
Yes, yes. MCIs apply to all of the rent stabilized tenants in the building.
Okay.
And it would be an indirect, it's either, what the law says is that are either directly or indirectly benefited. So an
Mhm.
elevator in the building, that would be an indirect benefit to the tenant on the first floor because they're living in an elevator building, for example.
Right.
But yes,
Right. So even if it's not, if you're not affected directly, you still would have to pay if it's just right.
that's right.
You still
That's
have to pay the MCI. Okay.
Yeah. As long as it benefits all of the, if a landlord only let's say one side of the building had
Mhm.
one elevator and another side of the building had a separate elevator. If a landlord only replaced one of the elevators, then no, because that's not benefiting. Like, let's say there's different entrances or something.
Mhm.
Think of some way, but that would be an objection that a tenant would make. It
Okay.
all of the equipment was not replaced, for example, right? But generally it needs to, in order to qualify for an MCI, it needs to benefit all of the tenants directly or indirectly.
Okay. Um, if my landlord replaced my building entrance door, is that considered an MCI?
Well, we could pull up the reasonable cost schedule, and what you'll see on there is a list of items that DHCR considers to be MCIs.
Mhm.
And I just want to reiterate that just because something is on the reasonable cost schedule or on the useful life schedule, it doesn't mean that the landlord doesn't have to meet the qualifications of depreciability, of everything set forth in the statute. Just because it's on the list doesn't mean that they're exempt from those other portion, from the requirements of the law. But the list what's listed are common MCIs on the reasonable cost schedule, are common MCIs that DHCR, that have come through the agency. I can't say specifically whether one front entrance door, I suppose that's possible.
Mhm.
I don't know. I've never done an MCI. I mean, there's doors, vestibule doors are a 15-year useful life. So I guess I don't know.
It's
This
more, right.
where this is where case law would come into it. Let's say there's an outside door and then the internal door.
Right.
Does the landlord have to replace both of those to qualify for an MCI? I don't know. Like
Mhm.
those are the details that would be in case law, where because maybe just replacing the outside door, not the immediate internal door, maybe that doesn't qualify for an MCI. I can't say doors, yes, but I don't know without looking at the
Right.
building, whether there's only one door. But if it's just one lobby vestibule door, yes, it's MCI eligible. Still needs to meet the qualifications, but yes, it's MCI eligible.
Right. Okay. I don't see any more questions as of yet,
Right?
but a question that I see that came up frequently was about, I guess, like if you disagree with the MCI. I know you touched on it before again, but maybe just to reiterate, if you disagree, what should be your first step of action?
The when you say disagree with the MCI, do you mean an MCI order or an
Yeah,
MC?
order, like a order, yes. The order that was like approved.
Right. So, well, the disagreeing with an MCI order has to assume that the tenants already objected to the rent administrator.
Okay.
We have to look at DHCR as in two parts: the rent administrator and then the PAR examiner, right? So the PAR examiner will look at what the rent administrator did and see if there were mistakes.
Hmm.
So if the tenants filed objections based on, any number of objections, whether it was defects or, the work was completed. I mean, the work was completed more than 2 years before the application. Any of those issues, then those would have been brought to the rent administrator. And if a tenant disagrees, then yes, you file a PAR within 35 days of the date of the order.
Okay.
Not 35 days from when you receive it,
Hmm.
35 days from the date on the top of the order.
Okay.
Absolutely file a PAR if not, and again, disagree, I don't quite know what that term means,
Hmm.
right? So in this context, so if the objections were ignored or you feel the rent administrator made a decision that's contrary to what the law is, then yes, you would file a PAR.
Hmm. And a PAR,
The petition for administrative review, excuse me.
right.
Yes,
And
that's
you
all within the agency.
okay.
And then if a tenant didn't like the PAR, let's say, it goes before the rent administrator, and then the tenant files a petition for administrative review with DHCR objecting to the rent examiner's order,
Mhm.
and then the PAR examiner makes an order that the tenant disagrees with, the tenant can file an Article 78, which is asking the court to review.
Okay.
And we frequently do that, file. And as a matter of fact, right now, and I have to say this only because it's one of the handouts distributed, DHCR handouts, the reasonable cost schedule. We have, on our firm, on behalf of the Tenants Association, filed a lawsuit against DHCR challenging their reasonable cost schedule. One of the key reasons is that DHCR has a provision in there that if it doesn't appear on the schedule, or it's work that's related, then we're going to cover that. But the law explicitly says, DHCR has to make a reasonable cost schedule and list everything that is reimbursable and put a cap on it. So if items are not on the reasonable cost schedule, it's been our position that the landlord doesn't get an MCI
Mhm.
for it, right? Because often, like, when there's work done, say on an elevator, there's like maybe a main contract, and then maybe there's other bunches of other little things that a landlord submits to DHCR seeking reimbursement for,
Mhm.
that are associated somehow, but not necessarily the MCI.
Mhm.
And so our position is, if it's not in the reasonable cost schedule and the landlord's asking for a rent increase, tenant should object to that. It's not on the reasonable cost schedule, so it should be objected to. The same thing for waivers of the reasonable cost schedule.
Mhm. Okay. Thank you for clarifying that.
Sure.
We have a question that just came in. Is asking for you to repeat the part about the percent of rent subsidized tenants not having to pay the MCI.
Sure, rent stabilized tenants, not rent subsidized.
Yeah, rent. Okay. Mhm.
Right, it's 35%. If a building has 35% or less regulated tenants, no MCI. So if there's 100 apartments and there are only 35 rent stabilized tenants left, the landlord doesn't get any more MCIs.
Okay.
That's how it works.
Okay.
And sometimes it's on the cusp, you got to look, because, well, at least now that, there's not deregulation, but landlords, prior to the HSTPA, deregulated apartments so frequently that some buildings only have a few rent stabilized tenants left.
Mhm.
And some landlords certainly might still file for MCI applications. Absolutely. And it's up to the tenants to raise that objection.
Mhm.
I mean, DHCR can certainly do it. They
Right.
should sua sponte, but who knows?
Mhm. Okay. Someone says my rent was 1,300. Then I had a MCI of $25, making my rent $1,400 on my new lease. They want to charge me 2% of the 100.
I'm
Not
not quite
yeah.
following. So,
Right.
right. So what it would be, let's say if your rent is 1,300, let's make it easy because I'm not good at math. So,
Well, it said the exact amount was 1,375.
okay. So, well, let's say your rent is $1,000
Mhm.
and you get an MCI, and the MCI is, um, wants to raise it, $70, whatever, like $15 per room or something. So you can only raise that 2%, which would be $20. And then the next year, another $20. And then the next year, another, or whatever, your rent would keep going up with RGB. So it would be more than 20, but only 2% of your rent can be an MCI.
Mhm.
even if the rent, but the landlord can keep every year, they can, every lease, they can continue to increase it, the rent, for until it's the 30 years are up,
Right.
but they can only do it increments of 2% a year.
Okay.
So at the end of, let's say 10 years, you're going to be at 20%.
Okay. So hopefully that answered, and hopefully that was helpful to you. Would you please put this information in the bullet format and the fact sheets? Must appreciate your presentation, which has been very informative. Yes, so this information will be sent out. We will be sending out the fact sheets. And also, if Michelle, if you could send me over the reasonable cost schedule, I don't know if that's in a PDF format maybe, and I could just
Sure,
do
yeah.
that.
Let me do that right now.
Yeah, so we're gonna follow up with everyone on this call who attended tonight with the information discussed, so you guys can review it over, more in depth. So, but as of right now, I don't see
Okay,
any
so
more questions.
I put in the link to the reasonable cost schedule,
Okay.
sorry, in the chat.
Mm-hmm. Thank you.
Is that okay? Yeah.
Yeah, that works.
Yeah, I mean, I could put the other links in if you want me to, if it's easier. Well, you're going to send them out anyway.
Yeah, I'm gonna send them out, so you don't have to put them all in there.
Okay.
Okay. But thank you for doing that. So I think I'm gonna conclude tonight because I don't see any more questions. So I want to thank Michelle again for taking the time to explain MCIs in depth and giving all of our attendees this valuable information. Like I just said, we will be sending out the DHCR fact sheet that was discussed and the reasonable cost schedule as well. And we also, well, Michelle, do you want to give them a contact information if they would like to contact you? Or how do
Yeah, absolutely. You know what? I'll put my email in
Okay.
the chat. Is that good?
That's perfect. Yeah. Well, you know what? Give it to me and I'll well, write it first and I'll put it. Yes, okay.
There we go. And our website,
Okay.
which has our contact. But definitely, if you have any questions, you can email me. I don't put my number. I've been out of the office. I've had COVID, so I only just now for the first time, but I'm still going to be out of my office till the new year. But I will be, but you could shoot me an email, is fine.
Well, we just got one more question. This will
Okay.
be the last one. I think it may be confusion about if MCIs apply to rent stabilized or subsidized. They're asking, does it fall if you're rent controlled?
Yes, rent control, yes.
Okay.
Rent control and rent stabilized apartments are subject to MCIs, and it's a 2% cap.
Okay.
Now, under the HSTP, it's 2% now. It used to be 15% and 6%. 15% for rent control, 6% for rent stabilized. But tenants who had MCIs anytime after it was June 16th of 2012, their leases should be amended already to get rid of the 6% increase and make sure that that drops to 2%. Like going forward, right? It has to drop to 2%. So if your landlord had been charging you a certain amount each year based on 6% from a 2012 MCI, and it's, listed, that should drop down to 2% now.
Okay.
Not 6% any longer. Yeah.
Okay, got it. All right, so thank you again. Thank you to our attendees who stayed on this call tonight with us. We appreciate you, and we hope this webinar was a source of learning for you guys tonight. And also thank you to Daniel, our interpreter, who's been interpreting this whole webinar for us. We greatly appreciate him as well. And lastly, I'm gonna put up a small poll just so you guys could let us know how this webinar went for you tonight. So if you could take a few minutes just to answer that, we will greatly appreciate that. Michelle, if you want to give some final words, you can. Final departure.
Just make sure that if you get an MCI notice from DHCR or your landlord, that you foil the application and that you look at it with, all of the regulated tenants in the building and decide how to proceed. Tenants are on the ground and know more than anybody what the condition of the building is and what the conditions of the claimed improvements are.
Mhm.
So that's the first step, first line of defense, and object.